All rise. Hearing, hearing. The Board of Appeals for the First District of Texas is now in session. Pursuant to adjournment, that I take the Constitution is on the court.
Please be seated. All right. Welcome to the First Court of Appeals. We have one case on the docket this afternoon, case number 012185, CV, Bay Area RV Parks, LLC, and Charles Simmons versus WGB RV Parks, Judson Welling, and Jonathan Gibbs. May we have appearances, please?
Your Honor, for the, I think, cross appellants, but I think we're the only one with remaining appeal points, so we're the appellants, Jonathan Gibbs and Judge Welling. I'm Lance Arney of regular minority.
Okay.
Todd Trump, I'm here for Bay Area RV Parks.
I'm sorry, can you say your name again?
Todd Trump,
Okay.
T-R-O-M-B-L-E-Y.
All right, and has the appellant reserved time for rebuttal?
Yes, I did.
How much time did you?
5 minutes.
5 minutes, okay. With that, I think we're ready to begin.
Thank you. May it please the court. On the, just a preliminary issue, and I don't want to use up too much of my time, I know I alluded to it, that on Monday, the cross appellants submitted a letter saying that they were withdrawing their sole cross appeal point as moot based on the settlement agreement that had been reached between our parties below. I think we have a different view over the effect of that settlement agreement on the issues on appeal. Certainly we intend to argue all of our appeal points. None of them have been mooted by the settlement agreement. And so just in fairness to Mr. Trombley, in case he was assuming that we had the same view, we do not, and we're still asserting all of those points. However, obviously it's their prerogative to withdraw their cross point if they wish.
What is your position on how the settlement impacts our remedies here?
That it doesn't at all, Justice Ferris. Basically, the parties entered into a settlement agreement that affected certain distributions from the company's funds. We agreed to escrow certain amounts that are, in our opinion, owed to my clients pending the resolution of this appeal, and that's why, among other reasons, the resolution of this appeal is important. But the settlement agreement expressly did not touch the issues that are on appeal, so that's our view. And that actually leads into the just really brief factual background I wanted to give the court about the reason that the issues in this declaratory judgment are important is because they involve the payment of money or the distribution of funds out of WGB. Mr. Welling and Mr. Gibbs, with a third partner, had founded WGB more than 10 years ago. In 2017, they brought on a fourth partner, Bay Area, the appellee, in return for a capital contribution of $500,000. In 2019, 2 of the company's 3 RV parks were sold, and the evidence was uncontroverted that all 4 members, including Bay Area, agreed that all of the proceeds from the sale of those 2 parks would go to pay down the company's obligation to its secured lender, Moody Bank.
So, counsel, in looking at the proposed findings of fact and conclusions of law, that point that you just made about a subsequent agreement to allocate or provide all funds from any profits to pay down indebtedness, why weren't there any findings proposed along those lines?
Because, Justice Guerra, the relief that we wanted was simply a declaration, and this is the severed, we severed the issues that were only addressed by the competing declaratory judgment actions for this bench trial. And what we wanted was a declaration that, pursuant to sections 5.1 and 8.2 of the company agreement that are unambiguous, Bay Area was only entitled to a proportionate 25% share of any distributions that were made. The payment of The payment down of the loan had already happened and was not an issue. No one was complaining about that. What Bay Area was saying is that they were additionally entitled to, not that they should have gotten part of that money, but that they were in addition entitled to a preferential distribution of $500,000, which is the money that they had paid in to join the company. And that was the issue that we needed declaratory relief from the court on, that they are not entitled to a preferential distribution, and in fact, Bay Area is only entitled to 25% of any money that in the future would be distributed. But that's kind of a long answer, but the short answer, Justice Guerra, is that payment had already happened, everyone agreed to it, and no one was complaining about it. The competing declarations were ours. The Bay Area is only entitled to 25% of any distributions, and Bay Area's proposed declaration, which in their amended petition that was filed in September 2020, they say that Section 5.7 provides for a priority of payments. And again, payments, in our view, are like distributions. We disagree with that. The distributions or payments are governed by Section 5.1 and 8.2. Section 5.7 is a tax provision. And that was the issue joined to the court.
Well, one question that I have is, it doesn't appear to me that anyone requested a finding or conclusion addressing exactly whether what you've just posed, whether 5.7 deals with distributions, is about money changing hands, or is simply about accounting for tax purposes. And so one question that I have is, both parties here have said that this is unambiguous in their favor, but this has obviously caused a lot of confusion, and this is not the most clearly written provision that I've ever seen. What happens if we think this is ambiguous? The trial court found that it was unambiguous, but what happens if we disagree and think that this is, at the very least, confusing and susceptible to more than one interpretation?
Sure. So, first of all, we do not believe that Section 5.7 can fairly be read. In order to find that it, or to hold that it's ambiguous, the court has to find that it's susceptible to more than one reasonable meaning, and we think because it refers to profits, capital P, which is a tax provision, because the only other section that Section 5.7 refers to is Section 5.2, which is also a tax allocation provision, that it cannot be reasonably read to affect distributions of payments, that it's a tax allocation provision. And based on the pleadings that the parties went to trial on, I think neither side pled ambiguity, and of course the relief that we're asking for is a reverse and render for the declaratory judgment that the trial court should have given in our favor, giving us relief that there's no preferential right to distributions.
I think the confusing point is not the reference to distribution and allocation. I agree with you on that the 5.7 does use the term allocated, which is found in the tax provisions, but then you get to this phrase, first to return the unreturned capital contribution, and return sounds like money changing hands, whereas allocation sounds like moving numbers around on paper. So it does appear to me that there's at least some potential for confusion. So if it were ambiguous, what would happen then? Would there need to be additional parole evidence considered in the trial court? Is there no such evidence?
Right.
What's your take?
So, and I've struggled with this a lot also.
Mm-hmm.
First, there are no pleadings that raise this issue, and we see on our brief. The tax filings are not at issue. No one complained about them. The tax return for 2019 wasn't even filed until like 2 weeks before the bench trial, and Bay Area's principal, Mr. Simmons, was appointed the tax matters partner or partnership representative to file that. So no one at trial was complaining about it, and the pleadings do not raise any issue. So I agree that Section 5.7 is difficult to interpret. I would note that there are other sections in Section 5.2 and also the capital accounts where they also refer to returned or unreturned capital contributions. Once you dive into these tax issues, then you're talking about Section 1231 income, whether it's return on capital, return of capital, whether it'll be capital gains or ordinary income, and all of those things are complicated and probably require experts to figure out. None of the pleadings raise any of those questions. So respectfully, I think the best answer I can give to your question, Justice Ferris, is there are no pleadings giving rise to a question that this court could remand the trial court to figure out. There's just nothing supporting a further proceeding on that because no one raised it. That is basically the issue on contract interpretation. We have a proposed declaratory judgment. The trial court actually found in our favor as a conclusion of law that the company agreement does not entitle Bay Area to any preferential distributions, but then the court failed to actually enter a declaratory judgment that assisted the parties in understanding where they go from here. The one finding that the court made in its judgment was that Welling and Gibbs had failed to satisfy Section 5.7. And that does not help any of the parties. None of the parties were able to take any action or do anything. It didn't resolve anything between the parties. And also, as we explained in our brief, we think that conclusion, that finding, is not supported by the evidence, and it's also contrary to the evidence that Welling and Gibbs aren't the ones who did anything with the tax return, that it was Mr. Simmons, Bay Area's principal. So there's no factual support for that finding. I want to jump ahead to the other issue on appeal, which is the trial court's award of attorney's fees to Bay Area. We believe that that award is, first, neither equitable nor just, as it would need to be under the statute, because Welling and Gibbs actually obtained, at least as a conclusion of law, the relief that they wanted. The court agreed that Bay Area was not entitled to a preferential distribution.
So in response to that, what do you make of the provision that does not require the party to be a prevailing party in order to be entitled to attorney's
Sure.
fees?
So, and I've read many cases that talk about that as a proposition. But then when you look at the cases where attorney's fees are actually ever awarded to a non-prevailing party, those are very few. And in each of those cases, there is some equitable reason for it. A party has unduly lengthened the proceedings, or there was a case out of family law where the husband was seeking to construe an insurance policy that affected his stepchildren. And so there might be a reason for a court to say, in that case, well, it would be equitable to award attorney's fees because that effort helped resolve the dispute among the parties. But in this case, the only basis apparent from the record that would provide a equitable or just reason for the court to have awarded attorney's fees in favor of Bay Area and against my clients was this finding that Article 5.7 had been failed to be satisfied by my clients. There's no indication that we lengthened the litigation, that we took bad faith positions, or that we lost. So the court's discretion to award attorney's fees under Chapter 37 is limited by the principle that it has to be grounded in something, some equitable or just reason. And again, the only finding against my clients that they did anything at all was that they failed to satisfy Section 5.7, and that finding is not supported by any evidence. In addition to not being equitable or just, we also have the issue that there is no legal or factually sufficient evidence to support the amount of attorney's fees, because the evidence submitted by Bay Area was based solely on the attorney's contingent fee agreement with Appellee. He did not ask for a specific amount, and even under Arthur Anderson, that evidence would not have been sufficient, but certainly once the Supreme Court resolved all this uncertainty with the Rormus decision in 2019, a year before our bench trial, it was crystal clear to all litigants that in any fee-shifting situation, the lodestar method applied and a party had an obligation to introduce evidence of specific tasks, the time spent on tasks, who did them, what day they did them. I understand you don't need contemporaneous billing records in all cases to support that, but the party at least has to have some evidence that supports an award under Rormus. And also, while I recognize that in many cases, especially before Rormus, the remedy for absent evidence of attorney's fees was a remand so that could be developed, there are some cases, and we cite them, the OMB Farms case, the San Antonio County case in our brief, where there is actually a reversal and a render or a modification of award on attorney's fees. And in all of those cases, trying to understand the difference between those cases where it's rendered or the attorney's fee award is vacated and the cases where it's reversed and remanded are, in those cases, the party did not even submit evidence, like in this case, indicating the amount of fees. They didn't even start down the road of demonstrating what their evidence was. And that is far closer to this case because we didn't have any amount of hours, we didn't have an hourly rate, we just had a contingent fee, and that is not adequate, and certainly under Rormus. So I'll...
Thank you.
Thank you.
Mr. Tremblay, once you get settled there, could you begin with the settlement and what impact you think that has on the issues before the court that remain?
Sure. Judge, the settlement doesn't have any impact on any of the remaining issues. The remaining issues before the court are, one, does Section 5.7 have controlling effect in this case for purposes of allocating profits according to the plain language of the agreement? Number two, the other issue is the attorney's fees award that Bay Area got. The other issue is whether, although Mr. Arney didn't really address it in his oral argument here today, whether they are entitled to attorney's fees. The issue with respect to that is whether they're considered to be a prevailing party or not a prevailing party. So
I had a question for you on the settlement point before we get to the other points. Because there's no longer an appeal of this conclusion of law, that the court further concludes that 5.7 does not obligate the supermajority interest to distribute the profits allocated to the plaintiff from the sale of the two properties. Aren't we stuck with that? Whatever we decide as to the merits of your opponent's view, at the end of the day, don't we have to keep what the trial court said about 5.7 since that particular section is no longer on appeal?
I agree.
Okay, so that's...
Unless the court decides to do something in terms of finding the contract to be ambiguous, then if that's the determination of the court, it may sound like all of those findings of fact are out the window.
And what is your take on if the provision's ambiguous, would there be parole evidence that the court should have considered? Should it have considered the evidence about the verbal agreement with respect to what was supposed to happen to the proceeds?
Well, the way I would address that, Your Honor, is I think the trial court got it right when it reached the decision that the contract is unambiguous. Nobody's ever disputed in the case whether the contract was or was not ambiguous. We have different interpretations of what the effect of various provisions are in the contract. But I think the important thing, if you look at 5.7, you'll see that that is an allocation provision, which is different than the provisions that Mr. Arney is talking about here today, which deal with distributions, okay? So 5.7 is incredibly clear that it says if there's a sale of the property, which happened in this case, and this whole agreement was 3 or 4 guys got together and they formed an RV community park company where they would buy properties for RV parks, okay? They sold several pieces of property. It's undisputed that they made a profit. The profit was like $2.7 million. The contract says, notwithstanding anything else in the contract, the first thing you do with profits is you return the unreturned capital account to 0.
But isn't that about allocating for tax purposes and not distributing, which would be actually?
No, it deals with where profits go first. Mr. Arney's clients had a 0 balance in their unreturned capital account. Bay Area had $511,000 in their unreturned capital account. Bay Area said, I'm entitled, according to this provision, to get this amount back plus the percentage of profits on the sale. Mr. Arney's client said, no, it doesn't work that way. We proved, and the court agreed with us in the findings of fact, that section 5.7 had controlling effect, and the law that we've cited in our brief and to the trial court is the Heinrich case, or the Heimerlich case, which specifically says that if a contract includes superordinating clauses or languages within the contract that say one provision should be given effect over another or all others, then that provision has to be given effect.
Well, to me, it's very unclear what the trial court did here, because you do have this conclusion that Section 5.7 does not obligate the supermajority interest to distribute the profits allocated to the plaintiff from the sale of the 2 properties. So how could the court have interpreted it to require money to ultimately end up in your client's pockets if we have this conclusion that says that that's not what's required here?
But if you look at 5.7, 5.7 doesn't say anything about a supermajority interest being required for purposes of allocating profits first from the sale of the property. It doesn't say anything about that. And so based on that provision, plus the law that talks about the legal effect of superordinating clauses, which is a big fancy word. I didn't know what that word meant until I read this case. But notwithstanding anything else in the contract means something. I mean, it clearly says you can ignore everything else except this provision when it comes to allocating profits first.
So, Mr. Trombley, do you agree that there was a subsequent, I suppose, oral agreement by the partners to distribute profits first and only to indebtedness?
I believe that, I don't know for certain, number one, to answer your question. Number two, I think that was hotly disputed between the parties. And you'll have to forgive me because I wasn't the trial lawyer trying this case. But I think there is a dispute as to whatever this parole agreement is about what to do with profits.
It wouldn't be parole evidence, right? Because it's subsequent. It's parole evidence, isn't it? Typically, whatever happened before the contract was formed. So
Understood.
aren't we allowed to consider subsequent agreements, especially in a partnership agreement like this that does not require any modifications or alterations to be written?
Well, I think the contract itself includes language. It's towards the back of the contract. It says, this is it. There are no side agreements. There are no other agreements.
Well, but
it's all contained within the writing.
I think there's a provision regarding amendments that, in my experience, usually would have had to been required to be in writing, but this one, section 11.7, page 32 of the agreement, does not appear to require any written amendments. And specifically with regard to the member's share of allocation of profits. And again, do you agree that if there was a subsequent oral agreement that would not be parallel evidence, because parallel evidence, I think by definition, is usually what comes before the contract?
Respectfully, Your Honor, I would disagree with that. And the reason I say that is because under section 11.11, it says entire agreement, this agreement and the schedules and exhibits herein contain all of the understandings and agreements whatsoever kind and nature existing between the members with respect to the subject matter hereof and thereof, and supersede all prior agreements and undertakings.
Well, my understanding is that this came later, and so even if this was the entire agreement at the time, there was a later in time agreement that all of the profits from the sale were going to go to the payment to Moody.
Well, I still think that qualifies as parole evidence because it's evidence extrinsic to the agreement. It's evidence extrinsic to what the parties agreed to in writing. So that's one issue. The other issue is there's no finding of fact by the trial court that addresses any of this. The trial court they weren't asked to, and they didn't make any findings of fact on this issue of whether there was some sort of side agreement. Okay?
So would that have, whose burden would it have been to have procured a finding?
It would have been their burden. It would have been their burden of proof to request a finding of fact on that in order to try to demonstrate whether the evidence in support of the other findings of fact are legally sufficient.
But didn't they, wasn't there testimony at the trial that there was such an agreement, and or can you point us to somewhere in the record where someone testified that there was definitely not such an agreement?
I can look for that, Your Honor. I don't have it with me here today about what the testimony was from both sides on whether there was a side agreement. Okay, but I will say this. They have challenged the trial court's findings on breach of contract on legal sufficiency grounds. And so if the court applies the City of Keller versus Wilson legal sufficiency test in evaluating the findings of fact, that's what the Texas Supreme Court has said that you have to do whenever you're evaluating findings of fact, not conclusions of law, but findings of fact, and that all inferences are supposed to be resolved in favor of the fact finder's decision. They would have had to have obtained a finding of fact as it relates to this side agreement. So the presumption that the court can make in this regard is that, let's assume that there was conflicting evidence provided to the trial court. If there was, the trial court was free to disregard it.
I agree with you if there was conflicting evidence, but what if there wasn't? I mean, the evidence is the evidence. If it's uncontroverted, do we ignore uncontroverted evidence just because didn't make its way into a finding of fact?
I would say under the legal sufficiency analysis that the court is required to apply, even if they provided evidence that there was some sort of side agreement, and that side agreement is what should have controlled. And you'll have to forgive me, Judge, because I just don't have the record memorized. I believe that there was testimony at trial to contradict that.
Is there any, is that part of what's been severed in this case? I know there's still ongoing proceedings in the severed action. Do you know, is this side agreement part of that, or?
No, and Mr. Arney could probably fill the court in a little bit better on the other action. We're waiting on the trial court to enter a final. That case has been tried to a jury. We're waiting on the trial court to enter a final judgment in this case. It hasn't. You all will probably be reviewing that one as soon as the judge enters the order And that one's probably even more of a mess than this one.
Oh, great.
Just fair warning.
And could I ask you to address one more issue, and my colleagues may want to come back to this contract interpretation point, but are there any cases that you can point us to that say that the contingency agreement is enough here to satisfy the evidentiary burden for attorney's fees?
Yes, 2 cases. The Roar Moose case in footnote 10 and the Arthur Anderson case. This case presents it's a really, really interesting issue on attorney's fees because this case really kind of presents the intersection of where contingency fee agreements cross over between this required lodestar calculation, okay? And so, I mean, Roar Moose says what it says on lodestar in the sense that it says, look, lodestar is simple. You start out with what's a reasonable rate multiplied by a reasonable number of hours. That gives you the attorney's fees. Now that amount, go to the second step. That amount can be adjusted up or adjusted down based on certain specific circumstances that there have to be evidence on, okay? In this case, what we're really only focused on is the first factor, because if you read through all of the discussion in Roar Moose, when they do discuss contingency fee agreements periodically within the opinion, you'll see that the U.S. Supreme Court and federal courts have typically been reluctant to adjust fee awards based on contingency fee agreements under the second element. Instead, they deal with it all in the first element. And so, if the court will look at footnote 10, and the reason I invite the court to look at footnote 10 is remember, Roar Moose was not a contingency fee case. Roar Moose was an hourly fee case. So they weren't being asked to address whether or not lodestar, reasonable number of hours, reasonable rate applies to a contingency fee agreement. But they talk about it in footnote 10. Now, Arthur Anderson was a contingency fee agreement case. And in Arthur Anderson, let me find it for the court real quick. Okay, so according to Arthur Anderson, in a fee-shifting situation, to establish that a contingent attorney's fees is both reasonable and necessary, the expert testimony comes from the lawyer, which it did in this case, came from the trial lawyer, Alex Klein, put it on in narrative form. The lawyer will go through each of the Arthur Anderson factors, which Mr. Klein did at trial. He went through every specific Arthur Anderson factor and discussed it within the context of the contingent fee requested to be awarded. The other thing that you have to do under Arthur Anderson is that the fee must be requested and awarded as a specific dollar amount, not as a percentage of the judgment. Mr. Klein did that. Through his testimony, he testified that the contingent attorney's fee in this case is 40% of the $511,000. It's not based on what would ultimately be in the judgment. So he satisfied both of those elements. And so if you go back and look at...
Counsel, I'm sorry, I'm not following that. Isn't that actually, yes, the actual specific percentage of the amount that they were seeking?
Well, it is. And in this case, those two numbers happen to coincide. But the award was not requested as a percentage of the judgment, the ultimate judgment that would be entered by the trial court. Instead, it was a percentage of a specific dollar amount. And remember, the record shows that Mr. Klein also put on evidence that the fee would go up to 45% in the event that there was an appeal. And the court didn't award those fees. The court only awarded 40% based on the $511,000. So, but turning back to the issue in footnote 10 in Rohrmoos, it says, when fee agreements provide for arrangements other than hourly billing, the attorney will not be able to present evidence of a particular hourly rate billed or paid for services performed. And that's true in this case, because it's a contingency fee agreement. Footnote 10 goes on to say that when an attorney cannot present evidence of a particular hourly rate, the expert has the burden of showing that the rate, okay, doesn't say hourly rate, it just says rate. And here I would submit to the court that that is the percentage of recovery. The expert has the burden of showing that the rate is a reasonable market rate given the considerations of Arthur Andersen. The testimony that was put on by Mr. Klein was undisputed in that regard. He testified that 40% is a customary rate for this type of commercial litigation. There wasn't any opposing or conflicting or contrary testimony presented by Mr. Arney in his affidavit on that issue. So, footnote 10 also says, and this is in a parenthetical citation to Arthur Andersen. For contingency fee cases, the fact finder must decide the reasonableness and necessity of fees in light of the Arthur Andersen factors to arrive at a specific amount. In this way, the contingent nature of a fee is taken into account in calculating the presumptively reasonable fee in the first step of the analysis. So, the problem with Rohrmoos in this case, which the court may or may not struggle with, but if I was on this court, I think I would struggle with it, is Rohrmoos didn't address contingency fees. It addressed hourly fees. But now this court is faced with addressing a contingency fee and applying what it says in footnote 10 along with what the court has always understood as a part of Arthur Andersen. I have only got 2 seconds left. It's reverse and remand under Rohrmoos and under KB Holmes. It's not reverse and render. If there's a dispute as to whether or not the evidence of attorney's fees was legally insufficient, that's important, right? Because legally insufficient points are typically reverse and render, right? But not for attorney's fees. Reverse and remand. So I'm not sure what the cases are that Mr. Arney talked about, but there's 2 Texas Supreme Court cases that say that, where the Texas Supreme Court found the testimony was legally insufficient. At the end of the day, we request that the trial court judgment be affirmed with respect to the attorney's fees. If the court is inclined to reverse that award, we would respectfully request a reversal and remand to the trial court.
Thank you.
I'll jump in and just start with Rohrmoos because footnote 10.
And I hate
Yes.
to do this, but I wanted to ask you this before, and you were on a roll, and I didn't want to interrupt you, but I want to go back to section 5.7.
Okay.
Can you please walk us through how this provision is not requiring the actual return, the payment of monies to Bay Area?
So the agreement in that section says what it says, and that's what the court found as well, right? That's the court's conclusion. Section 5.7 says that profits, capital P, shall be allocated first to return the unreturned capital contribution. That is, in our view, as we've said, a tax allocation provision. How that section works in the context of filing the tax returns and all the other tax provisions Section 5.2, which is the one referred to in Section 5.7, and all the other tax provisions, including the other superordinating provision in the company agreement that says, and by the way, everything has to comply with the IRS code, I can't answer that. No one has done that analysis. I have not done that analysis. Our CPA hasn't done that analysis to say, okay, here's when we report the profits under Section 5.7 on the tax return, here's how it is going to interplay with unreturned capital contributions. But what I would note, and I think Justice Ferris may have raised this, it has now been almost 2 years since that tax return was filed. And no one, to my knowledge, has complained about it. It was not raised in the original case from which this case was severed. Basically, there's been plenty of time if anyone feels, based on the tax return that was actually filed, whether it complied with Section 5.7 or not, and whether it had the effect that it was supposed to under Section 5.7. No one's complained about that. It wasn't raised in the trial court, and it's not raised in the pleadings.
So was it reflected in that tax return?
It was.
Was it allocated to the Bay Area's capital contribution?
It was profits. There were Section 1231 profits, and again, the tax return isn't in the record. It wasn't introduced by anyone, offered by anyone. The tax return does reflect Section 1231 income that was allocated to all of the members. I think it was about $1.2 million of profits. Now that's different from the $2.7 million that was actually received and that went to pay down the bank. There were no distributions made in 2019. There were not distributions made until this year. Now, with the distributions, yes, Bay Area has received back every dollar of its capital contribution plus more when, pursuant to all the parties' agreements, distributions were made. But as a tax issue, and whether those capital P profits then were allocated as a return of capital contribution or something else, that's just not in the record, and candidly, I can't answer that for the court because I don't know. I haven't studied that.
So then, did I understand you correctly that Bay Area has been actually officially has received as a distribution the capital contribution, separate from the check that I understand was written, is it by Mr. Bell?
Yes. The check, actually, we had a temporary injunction hearing with the court. Some of that transcript is in the court's record, or in the record. And the $500,000 was put back into, basically handed over to a receiver pending resolution of all this. So the $500,000 got put back into the company, essentially.
So really the fight is about the attorney's fees at this point?
Yes, I mean, the fight is about, first, is Bay Area entitled to a preferential distribution? And we think no. And they haven't complained about the tax return or said that it didn't do something that they thought it should do. So yes, the issue then is, okay, were they ever entitled to something that was a preferential distribution and attorney's fees? On attorney's fees, really quickly, we read footnote 10 in Wormoose to say, here's how this lodestar analysis is going to work in contingent fee cases.
And I'm sorry, I keep going back to this, but I want to understand. So they have gotten the $500,000 back.
Yes.
And so is that issue not moot now, if they've gotten it, or are they saying they should have gotten $500,000 twice? And I know that's not your client, but I'm trying to understand what the controversy is.
Absolutely. So, and this gets back to the settlement agreement, which was part of how the distributions were made. As part of the settlement agreement, we recognized that this issue was going to be heard by the court. We took the part that was disputed, that this issue affects, and put it into escrow. So that money is sitting there. If the court finds that Bay Area is not entitled to a preferential distribution, then my clients are going to get that money out of escrow. If the court somehow finds or directs the trial court to enter a judgment that, in fact, Bay Area was entitled to a preferential distribution of its $500,000, then that money would go to Bay Area. And Bay Area got the part of the money that was undisputed. All the parties got what was undisputed. But this issue, whether Bay Area gets a preferential distribution of its $500,000 or $511,000, that's not material, but whether how that issue is resolved is going to affect what happens to that money that's in escrow.
Okay, so now I'm confused again. So the money is sitting in escrow, the $511,000 is sitting in escrow, or it was actually paid to Bay Area?
So Bay Area received 25% of the money that was distributed. And my clients received 25% of the money that was distributed, except as to $500,000, which this is, whether there's a preferential distribution or not, we said, okay, we will pay Bay Area its part that it gets no matter what. But if we're right, and we are entitled, that should be split 25, 25, 25, 25, we are entitled to, I think it's about $380,000. So that money is sitting in escrow. But outside that $500,000, Bay Area also received in excess of $1 million, which is greatly more than its capital contribution. It's made a tremendous profit, and that is, but that's not disputed, and that's pursuant to the agreement of the parties. So, thank you. If I can, the one other case that's a reverse and render is a case out of Fort Worth, 427 Southwest 3rd, 511. That's another case where there wasn't even a step down the road toward satisfying the lodestar analysis, and I think Romers is clear on that. Thank you.
We have your arguments, and the case is submitted. Court is adjourned.
All rise.